Showing on Law Weekly today, we bring you some reactions trailing the situation in Bayelsa State following the swearing-in of the candidate of the PDP as governor of the state. We have the views of two senior lawyers. Also showing on the program, the Chief Justice of Nigeria, Justice Ibrahim Tanko, has asked judges of the appellate courts to put in more efforts to clear the huge backlog of cases and appeals awaiting their attention. Plus our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. It was on Thursday, the 13th of February, that the Supreme Court nullified the return of Bayelsa State Governor-elect Mr. David Leon and his running mate, who were billed to be inaugurated into office on Friday, the 14th of February. A five-man panel of the Apex Court, led by Justice Mary Peter Odili, ordered the Independent National Electoral Commission, INEC, to withdraw the certificate of return issued to the APC candidates and issue a fresh certificate of return to the candidates of the party with the next highest votes and with the required constitutional spread of votes in the results of the election. Predictably, a lot of reactions, both positive and negative, trailed that judgment. But it has since been complied with, and Bayelsa State now has a governor. Law Weekly sought the views of two legal practitioners on these developments, and we got some thought-provoking responses.
Legally speaking, the Supreme Court has done what it ought to do. The law is very clear, and it's been the law for a long time, not recent electoral acts. Once either of the candidates in the election, whether the running mate or the substantive candidate, the governor or president, is not qualified to have been, to have stood that election and voted in as, a candidate in the election, both of them automatically becomes disqualified. If they have been elected, their election becomes vitiated and nullified. And that's exactly what the Supreme Court has done in this matter. Initially, I was wondering how it became an issue that will be treated or be litigated upon through originating summons. Well, I later found out that it is actually not just about the issue of somebody not having a particular certificate or not qualified to have contested the election, but this particular candidate, that's the running mate to the governor, the then governor-elect, actually had a series of certificates in different names, which makes it impossible for any responsible, regulatory agency. I believe that if INEC was still in control of screening candidates, that man wouldn't have been the running mate to the now disqualified governor-elect. The initial law was that INEC decides who qualifies after screening, and if INEC screens you out, then you do not stand to be elected. But now it is the party, and once the party screens anyone, the person, there's nothing INEC can do. It's only the court of law that can now either nullify the election or disqualify the candidacy of that person. And unfortunately, I think that we should put the blame at the doorstep of the party. To me, this is the height of irresponsibility on the part of APC leadership. And the law even stipulates penalty for situation like this. If you ought to have screened someone and it's discovered later, and that person ought not to have been screened to stand the election, the party is supposed to pay a fine of, I think, 500,000. So I feel that the leadership of APC should ordinarily cover their face and even their head in shame, rather than this bragging and unfortunate, ridiculous accusation and allegation against the Supreme Court. for the judgment. Because what the Supreme Court has done is to simply interpret the law and to simply, initiate a process for ensuring that someone who was not qualified to stand the election was not, sworn in as the governor. As to what transpired, or the swearing in of the governor, yes, it's been sworn is already the governor. That is Diri. As long as the judgment has been served on INEC, INEC is duty bound to issue certificate of return, because the orders were very clear that the person who scored the next highest votes should be declared as the winner. And the candidate of the PDP, being the next candidate that scored the highest vote next to the then APC, automatically becomes the validly elected candidate. And APC candidate, having had, a K-leg, if I may use that word of Shiva Basanjo, that's a phrase they used to use, having had a K-leg candidate as the running mate, cannot be seen to have been validly elected, and they cannot enjoy the benefits of having been elected to lead that state. Because what it may amount to, and the whole essence of this law, to ensure that we do not have criminally minded people, and not just criminally minded, people of low integrity or probably total lack of integrity rule either the state or the country. And what this judgment has done for us is to teach the party lessons that if you are presenting any candidate, those candidates must be properly screened, ensure that you do not compromise the standard and do not bypass the law just because you prefer a particular candidate. You feel such person should go in even over those who are more qualified. Not. But now that they know that the court can, even if INEC is handicapped and is unable to disqualify that person, the court can always disqualify such person. I think this is a very novel development. It is, in fact, a very good development for the benefit of the sanity of our system.